I want to, while we were in court today, Mr. Syed wrote a statement, and I think it was very difficult for him to write it because he was in a 4-point restraint. And I'm not sure, I guess you all saw the back of his head, but he was in a very uncomfortable position for a very, very long time. Imagine just being shackled like this and not being able to move for hours and hours and hours on end. And he does have some physical issues. They're not serious, but he does have a problem with his shoulder. So anyway, he wrote out a statement. I'm going to read it to everyone, and it's pretty brief, but it says, "I'm incredibly grateful for the opportunity to present new evidence before the court. I'm incredibly grateful for the love of my family and friends who have stood by me all of this time. I'm thankful for all the support and encouragement I've received from so many different people from all over the world. The events of the past 16 months have filled me with a great sense of hope, and I intend to keep fighting to prove my innocence." And there's also a statement I have from the family. This one's a little bit longer. I think I'm gonna read some highlights. Nearly 17 years ago, Adnan was taken from his bed as he slept. He was taken by Baltimore City Police, and he has not been home since. He trusted his attorney as we all did, and she failed in her most basic duty of contacting an alibi witness that Adnan had asked her to contact, and years later, representing to Adnan that she had done it. We have been paying for that failure for 17 years now. Adnan was wrongfully convicted and has been wrongfully imprisoned since that time, having lost his direct appeal and the initial post-conviction. There are many people the family would like to thank. They would especially like to thank all of the people sort of outside of the judicial process who have helped make this possible, including Sarah Koenig and Serial, the people from Undisclosed iPod, Susan Simpson and Colin Miller, and they say that the last 4 days have been stressful and difficult, but at the same time they've been full of hope and promise because we believe the truth is finally coming to light. The same truth that Adnan and us have all held on to since 1999. Okay, so I guess I'll take some questions in a limited fashion. Anyone got a question?
It seemed that you were really offended during the closing argument. What was the, for lack of a better term, straw that broke the camel's back?
Well, like I think, and I addressed this with the judge at the start of my closing argument, that this is a case that we feel very passionate about. So we're out there fighting as hard as we possibly can. And while myself and Mr. Vignarajah might see things differently, at the end of the day, I have to acknowledge that he is a very hardworking and determined prosecutor. And I became frustrated with some of the comments and insinuations regarding to documents in the case. What's interesting is that the document about which Mr. Vignarajah was complaining was the very document that was in the defense attorney's file. So that if the FBI expert could not look at that document and interpret it because it was somehow truncated, which is essentially what it was half of it was cut off. If the expert from the FBI couldn't figure it out, I was posing the question, how could Cristina Gutierrez possibly have figured it out?
Abe Warano, it seems like he would have been, you would have had Agent McClain saying I was an overlooked alibi, and then Abe saying I'm recanting my testimony, but we didn't quite get him in there after 5 days. What happened there?
The judge made a very specific request to counsel late in the day yesterday, or he made it very clear to counsel, I should say, that he wanted to get the proceedings moved along, and that if we could convey the same information through an affidavit that live testimony would produce, he encouraged us to do that. We took him at his word and respected his request. So at the last minute, we decided to enter into evidence an affidavit from Mr. Woronowicz rather than actually calling him as a live witness. But I will say that he did get on an airplane and flew in from the West Coast and was here, and he was prepared to testify.
Can I ask you, it seems like there are sort of dueling views, obviously, of the bar that must be met for the judge to decide one way or the other. Can you sort of sketch that out in a little bit more plain speak for those of us who aren't judges?
Yes. So the test that applies to the case, it's a two-part test. We have to prove two things. And to put it very simply, one, we have to prove that the defense attorney, Christina Gutierrez, made a mistake. And number two, we have to prove that that mistake was significant. And that's really it. So if she made a mistake in trial where she referred to a red car as being a blue car, that might have been a mistake, but if it had no significance to the trial as a whole, then we lose. So we were focused on two issues, both of which we feel are, even by themselves, grounds for a new trial.
But the prosecution would say that the bar is actually not that. That if that were true, then there would be people saying that defense attorneys got things wrong all the time, and would be sort of endless. So what do you think of their view that the bar is actually much higher and the state has an obligation to defend its original ruling?
I think that the way I characterized it, although I sort of did it in layman's terms, I think the state actually would agree with that, because that's the law. I mean, the law is pretty simple as to what the standard is. Where we and the state differ is, number one, whether there was a mistake. The state has taken the position that there was no duty for Gutierrez to talk to the alibi witness. We strongly disagree with that, and we put on testimony from an expert witness to make that clear.
What's your confidence level as you sit here today?
I feel like the hearing went well for us. We accomplished the things that we wanted to accomplish at the hearing, and I gave up on trying to predict what judges are going to do a couple years ago because I've never been very good at it. So we try to take the attitude: we're going to go out there, we're going to do our best, we're going to put on our evidence, hope for the best. It's in the judge's hands, so I don't know. I don't know what he's going to do.
How much of all of this was of the argument? I mean, it was such a strange post-conviction hearing that became a trial. How much of it was for us, for the press? Because this only came to light because of us, it seems.
That's a tough question. And I think, it is sometimes difficult to ignore the fact that you're in a packed courtroom and there's a ton of press there. And we have made an effort to try to stay focus our attention on the judge, because really he's the only one in the room who matters. So I hope that we did a good job of that. I will confess that at times it does get distracting, having that many people in the courtroom, having press there, having family. Even my wife came out; she's never seen me in court before. So little things like that. It does change the dynamic, but I think overall, it makes everyone operate at a higher level, and I think that was a case that was bitterly contested. And I think on both sides, you saw good lawyering and people, really we fought hard for our client. We did everything we possibly could for our client to try to succeed. And from the state's end, I think the same thing can be said. They did everything they could possibly do to represent the state's interests.
Let me ask the same question a different way then, just because I didn't get actually, I don't think I got an answer. If I could take your position for a second. How important is what we're doing now, which is very rare for a post-conviction hearing, to the outcome of the post-conviction hearing?
I have a lot of confidence in our judges, and I think that the judges are going to very carefully look at the facts, and they're going to very carefully look at the law, and I have no doubt that whatever decision they make is going to be based on that. Now, that said, has the public attention helped us? Yes. I would be crazy to deny that. I think that one of the things that happened is that as a result of Serial, more information became available to us, information that we might not have otherwise gotten. So it definitely helped us. You know, people like Susan Simpson and Colin Miller and Rabia Chaudhry and this might have been the first ever kind of open source case, where all the materials from the case were out there. So people were investigating this case all over the country. I had essentially thousands of investigators working for me, and that produced information that we otherwise would not have had, and that helped us. That helped us get to where we are right now.
And as significant as that was, did it also backfire in terms of the state getting access to the defense file as a result of it? They used that as grounds to obtain the defense file.
When the decision was made to proceed how we did proceed, we had nothing to lose. We had lost the case. I mean, we were essentially lying in a coffin, and the last nail was being hammered in. And we made the decision to do that, and the decision paid off. So, would I have liked to have taken that file back and assert some kind of privilege over it? Sure. But the law is the law, and we took our risk, and there was some downside to it.
Let me throw out a hypothetical. I promise not to ask
about. Man.
I promise not to ask about space stations and whatnot.
Sure. Because
there is this consensus that Cristina Gutierrez, in her prime, was an absolutely phenomenal lawyer. You admitted to this. Mr. Vignaraja admitted to this. The one common question that I've been hammering over, based on talking to people who have covered her in the past, there must have been some reason why she did not call Asia McClain. Has that crossed your mind? Because obviously she is methodical, from what I understand, very tenacious and very absolute about how she works a case.
Look, I said this during the hearing, and I'll say it again. I have learned an incredible amount of information about Tina. And when she was in her prime, she was a force of nature. She was a fantastic lawyer, and she fought as hard as anyone fought. What we learned and what we discussed in the hearing was that there was a time when there was a decline, and that her skills were no longer at the same level that they were at in the early 90s. And, again, this isn't something that we didn't bring up in court. It is our position that what happened to her is she started to lose control of her operation. Her health suffered, and she wasn't the same lawyer in 1999 that she was in 1990. And I take no joy in that, but based on literally dozens of people who I've spoken to, that is our impression of it. and it's not to disparage her in any way, because